So it says do not detain, do not arrest. Who gives that authority?
The FBI.
The FBI tells you that you can't be arrested.
All you got to do is call them, sir, and they'll tell you.
They'll tell you I can't arrest you for anything.
Unless I violated the law and committed a crime where where injured party.
Most United States citizens are afforded that opportunity.
Well, no, they're not, sir, because most of them.
I can arrest people for no reason.
That's the license plate in this vehicle.
That's what they do. So when I'm traveling, I have to have my own tags. Yeah, when I'm traveling, I can't use somebody else's tag.
Says who?
What do you mean says who?
Says who? Who gives you that authority?
The Constitution gives me that authority, sir.
Okay. Well, the state of Florida has rules that if this tag is registered to this vehicle, it has to be on this car.
But state of Florida does not trump the Constitution.
Okay. Well, you know what you're going to have to do then? You're going to get tickets, and then you're going to have to fight it in the state of Florida court.
Oh, I have no problem fighting a ticket.
Excellent.
A ticket means nothing because you cannot ticket someone for exercising a constitutional right.
Okay.
See, I'm exercising a constitutional right to travel.
Okay.
Now, and see, this is the problem that I have with law enforcement agencies that really aren't very versed in the law. And see, this is what you all are thinking. You all think this is a motor vehicle. And see, this is what they're having to all the customers, all the clients in Florida to register their automobile as a motor vehicle, and that's wrong. The Supreme Court case, City of Dayton versus the Pro-Se, specifically states that the term motor vehicle is a broader and different term than the word automobile. See, automobile means you're not traveling for commerce or for pay. Motor vehicle means you are. That's the difference. And see, that's why I usually send a letter to the chief and the sheriff. I just want too long got here. So I'll be sending a letter to your chief of police and your sheriff so they can understand who I am, why I have to have my tag on whatever car I'm in.
Now, who issued this tag to you?
Who issued it?
Eric Holder issued this one?
No. Now
it's a private.
Yes, private. Yes, private attorney general. Yes, private.
Let's run his driver's history and see where he's at. Just stand by for a few minutes.
Where do you have a driver's license?
I don't have a driver's license.
You don't have any driver's license in any state of the United States?
No, sir. Do not have it. That's why you can call the FBI. So that'll put all this up. So you're not going to call the FBI to verify who I am? Are y'all serious?
You should have an ID proof who you are.
That ID proves who I am.
So do me a favor, put your hands behind your back right now.
Put your phone down.
Right now.
We'll record everything. Don't worry about it.
Let go.
What am I being arrested for? So you can't arrest nobody for...
Now let's head over to court and see how this case turned out.
75 years later.
I didn't understand the question. Can you come up here, sir?
Do I do so without my constitution and common law rights intact? We have a court.
Yes, you do. We may have a difference of opinion on what those are, but certainly you come forward with all the same rights that anyone else has. Although, according to some of your pleadings, you waive those rights, and
I've never waived those rights.
well, I'm just reading from what you.
Because I'm in trying to establish your personal history.
Are there any matters we need to address before we do?
Just take the notice of consent to use to that conviction for impeachment, take three motions in the limiting the defendant file. There's one motion limiting that you filed, motion limiting number 3. Most are very standard and straightforward, except for motion limiting number 2. Don't need to do that after seeing Mr. Williams litigating on his bond motion. That's something that the court has instructed. He can argue for a different clause, and then it's going to be given to the jury by the court. We cannot argue for jury nullification or anything along those lines of law. That's what the court did. I do not consent to none of that because that's unconstitutional. He can't direct me to not state any laws, because whatever laws there are, they have to be in accordance and harmony with the Constitution for the United States of America.
I'll hand you this United States Supreme Court decision that says the state has the right to require
have no problem with it if you have to have a license if you're driving a motor vehicle. That's not the dispute. Or that's not the dispute, whether you have to have a driver's license to drive a motor vehicle. I know you have to have one.
Well, then what's the dispute? Because that's what you're charged with.
Well, that's incorrect charge because I don't have a motor vehicle. I never was driving a motor vehicle. I was traveling in my automobile, and the Supreme Court has been very specific in regards to a motor vehicle as opposed to a private automobile that a citizen has a right to use the highways and the roadways uninhibited by any statutes, rules, or regulations that any city or state can legislate.
Well, that's an incorrect statement of the law, sir.
Well, I have the Supreme Court cases just like you. I have my paperwork with the Supreme Court cases that will be presented also.
With all due respect, Mr. Williams, I read all the cases that you submitted. None of them address the issue as to whether or not a state has the authority to impose requirement that the person have a driver's license when they're operating an automobile or motor vehicle only.
So they're two different terms. Automobile and motor vehicle are two different terms.
I've already ruled on it, Mr. Williams. I'm not going to rule on it again.
Well, I'm saying, but I have a right to present whatever constitutional law there is.
And if you provide any constitutional law that supports your position, I will allow it. None of the cases you have cited allow that, and I'm not going to allow you to argue that.
No, all the cases I have do state that. Those Supreme Court cases is very specific. It leaves no doubt or no room for even interpretation of it. And also, I
respectfully disagree with your interpretation of the Supreme Court's ruling.
Well, the only thing, that's up to the jury to decide. Because once they see the Supreme Court cases and also what the state law and the U.S. Code state, then it's going to be very clear that I was not in violation of driving on a suspended license with driving a motor vehicle because, number one, I do not even have a driver's license. Never contracted with the state of Tennessee, which is a corporation, to get a driver's license.
This constitutional law scholar doesn't understand that he just made an argument against himself. That is the whole point, sir. You're here because you were driving an automobile / motor vehicle. You were operating it without a driver's license, you nincompoop.
That this is a matter of contract, which I have not contracted, nor will I have a contract with the state of Tennessee to get a license for something that the Supreme Court has stated is a right, which cannot be converted into a privilege.
I'm going to advise the jury that that is not the law and they are to disregard it. Argue what you want, but I'm going to tell them that they cannot consider that and disregard it.
Well, if you tell them that, Judge, then I will have to file charges against you.
Well, it's
for a violation of oath of office.
Mr. Williams, it's not the first time that you filed charges against me, and I'm sure it won't be the last time. Please instruct your friend back there that he is going to go to jail if he videotapes any juror.
He understands that he's not afraid to videotape no jury. He understands the law that he can only videotape me and the prosecutor or persecutor.
Or
You refer to me as a persecutor, I object to that characterization.
exactly. All right. Is there anything else we need to address?
I mean, that there is a distinct, as long as because I have the actual federal law that's going to be cited. And
we're
the
not,
state law.
I'm sorry, Mr. Williams, this is a state court, not a federal.
Well, I understand that, but there's a conflict preemption law that states that if the state law conflicts with federal law, then the federal law preempts or trumps the state law.
I have nothing before me that indicates that's the case.
Well, I have the paperwork. I have the case law that does state that.
Where is that case?
I don't mean to burst your bubble, Anthony, but your sovereign citizen arguments are not going to help you win this case.
And as I've already stated, that I am requesting a transcription of these proceedings and also video recording that the state is videotaping also.
Well, you haven't cited me a statute, any federal statute that says, that a state cannot impose upon its citizens the requirement that they have a driver's license.
That's what that states right there.
I agree that you can't have state law that conflicts with state.
That's what I intend to present. That's why I intend to present the state law, where the state law is different than what the federal law states in regards to motor vehicle and who is liable to have a driver's license and who's not. These are the case laws that's on the book now. We need to, you all have a copy of the actual Tennessee Code annotated book and the U.S. Title Code book. That would be sufficient when we can actually show the jurors that it actually is written into the law so they can make that determination. Because I would not allow this court to not present or not allow me to present the evidence that's on the books as far as laws and statutes and also the constitutional law and show that there's a conflict with the state law. Because this law actually has been heard in the state of Georgia, and the state of Georgia has also ruled that it's against the law for a state to legislate motor vehicle laws that's contrary to the Constitution and the federal law. And I have that copy of that act with me here today also.
Submit it, but again, I rule on it.
I mean, whatever you rule in, I mean, this court doesn't even have the original jurisdiction. I mean, you've never had subject matter jurisdiction. Because if the state is a party, the state has...
I disagree with that as well.
I mean,
I've already ruled on all those.
Well, you disagree with what the law is. It's two different things, Judge. I mean, because what you're doing right now is a conflict of interest. Because you work for the state, and the prosecutor works for the state also. So it's a conflict of interest. And the Constitution states that when the state is a party against the citizen, only the Supreme Court has original jurisdiction. But this case, by law, should be heard in front of the Supreme Court and not in front of you. Now, do I need to read that out of the Constitution?
Read what you want, but you're wrong on the law.
This is Article 3, Section 2 in the U.S. Constitution. It says the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, the controversies to which the United States shall be a party, the controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming land on the grant for a different state, and between a state or the citizens thereof and foreign state citizens or subjects. In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So this is constitutional law.
So we're ready to bring up to this.
I'm ready.
demanded a trial and indicated you had no desire to discuss anything that you wanted the jury to decide the case, and so we, in an effort to accommodate your motion, we set it for trial. You're the one that waived the January 13th discussion date. Also, even if you had not waived your discussion date, you never filed a motion for discovery. That is a different view.
The reason why I did it is because you all think he did.
I gave that to you at the time of your arraignment.
That's the reason why I didn't submit a motion for discovery. Because on here, it said there will be a standing attorney order issued by the court.
And that you will sign your desire to have that. What do you have in this case?
I discovered everybody and the arrest report, affidavit, which is public record, certified driving history, letter from Mr. Birdwell, as to the driving test on February 2nd. All the exhibits that I had submitted on November 18th, motion to revoke the 33 package to be trial exhibits. And that's what he would be, there is no dash cam. That's important.
Specific, certain DUI enforcement vehicles.
Also, he has a prior criminal record, certified convictions since his death, his arrest record. We would have provided all that. So the state saying that the police does not have any type of recording device in the vehicle. The police don't have no recording device. This officer on the car he used, not he arrested you, did not. So, I'm just going after Dave for that fact.
You can cross-examine Officer Small with him, he takes the same.
Also, Jim, when it notes that there should be no hearsay testimony that should be heard or accepted. Anything that is presented must be proven constitutional.
If a witness begins to testify about hearsay, then you certainly have the right to object, at which time I will rule upon that. But I agree with you, as a general proposition, hearsay evidence is not admissible. However, there are numerous exceptions to the general hearsay rule. Since it's almost 11:30, I'd like to bring the jury up, start jury selection, consider lunch hours, come back about 12:30, we'll see where we stand with possible. Oh, there's, hold on just a second.
So Anthony Williams, cameraman, cut the camera there because I'm sure he didn't want us to see him lose this case. As we witnessed, this man came into court with the nonsensical sovereign citizen arguments that never work. So now let's get into the outcome of the case.
Anthony Williams appealed his January 13, 2012 Tennessee conviction for driving without a driver's license and alleged on appeal that he does not need a driver's license to drive a motor vehicle unless he is engaged in commerce, and that the state requirement of a driver's license violated his right to interstate travel. The court held otherwise and upheld the conviction. What you're looking at currently is the state of Tennessee versus Anthony Troy Williams in the Court of Appeals in Tennessee at Jackson, discussing that case and upholding the lower court's decision. Please note that this is the imaginary defense and the very same thing that is peddled by fake retired federal judge Rodney Dale, or otherwise known as Judge Dale, class, fake former Deputy Sheriff Eddie Craig, and fake constitutional scholar Carl Miller. Real name, Richard Champion.
Vamos